Yeah, that's it. Informally. So we'll go for the session. As Haveen was saying, I'm going to talk on patent. We have been talking about patent for the last couple of days. And today, what we are going to talk about is about the content of specification. Let's just recall what happens, or let's contextualize it so that we'll have the continuity of what has been happening in the last classes and what's going to happen in this class. So in the last class we talked about the non patentable inventions. Then we also saw who can make an application for patent. Then we went through those kinds of questions, and ultimately we reached an area where it is said that where it was understood that patent is to be acquired by process of registration, and registration requires an application, and the most important document that is filed along with the what do you call uh, with the application is the specification. So we reached the area of specification. We were at the total of understanding a specification, and a specification is a techno-legal document. Specification is a techno-legal document. I repeat, it has technical content in it, as we might just guess. It is describing into the patent office to which you are making an application for patent about the supposedly new technology regarding which you claim a patent. So it is definitely a technical document, but it has a legal texture. It is complying with legal requirements. So it is expressing the technical knowledge in a legal format, you could say. And a full and particular description of the invention, as you can see on the screen. I invite your attention to the screen as well. A full and particular description of invention and its operation or use and method by which it is to be performed. That's what is going to be found in a specification. And it is mandated in the uh, patent law, that the best method of performing the invention, the best method of performing. Best method is the most comprehensive method. It need not be always the easiest method. Is easiest method. That method may not be best method. Best should be all covering, an all covering thing, and it should be comprehensive. It should be should be most efficient. All these things should come into that when we speak something as the best. It need not be always the easiest. So that's understanding. And before we broke our session or interaction in the last class, as if you can remember, we have this list of contents of specification. So specification has a title. As you can guess, there could be a title for invention, and because you are describing an invention in the specification, and the field of invention, which field does that belong to? That's also an important matter, and you may have mentioned that as well in the complete specification, which you have with the application. Then you will have to describe and you have to give a background of the invention. What context does this becomes important? Then what's the aim of your invention? Because in the background you'll be speaking about the problems that society is facing these days or presently, which is not yet solved. And as far as the objective of invention is concerned, you're trying to give a solution through the patent for such a problem. And then you have the statement of invention. Then you have a summary of invention, which is the brief of it. And then going further, you have a brief description of the drawings accompanying the specification, which can be there. It need not be there always, but Usually it is there. And if you have a mechanical device which is being with regard to which you claim a patent, definitely you have you have a couple of drawings with regard to that. A brief description of the accompanying drawings, then detailed description of the invention with reference to drawings and examples, as you can guess it. And then you have claims. Claims would be the most important as far as the patent is concerned, as far as specification is concerned, because claims are the would tell you or would tell us about the scope of patent, or rather, you have a patent right, which is an exclusive legal right in uh, the area you have claimed your right on. I hope you are making sense. Uh, so if you have described something and if you have not claimed that in your patent, in your specification, that's not part of your patent. So it is important that you not only describe your invention in a best method in your specification, and you specifically claim to make specific claims with regard to that. So what's your patent would mean if you ask somebody, what's the question? If you ask the question, what's your patent on? Tell us about that. Or if you're trying to understand the scope of a patent for very many purposes, you could be looking at a specification. And then you should be looking at the claims. Of course, to understand claims, you may have to go to the description, but it is the claim that will tell us precisely and specifically as to what is the scope of the patent. And lastly, as a 10th point, you have a round number as well. You have an abstract too attached to a specification. So these are the 10 different parts you usually find in a specification, and it has a logic also behind it. Now, what we are going to do is we are going to spend some time to understand each one of these. And we are going to understand these through an example which can be found even in the patent office website itself. So, from what we are going to discuss for the next couple, perhaps for half an hour or so, no, I acknowledge the content, taking the content from Indian Patent Office. And of course, I've adopted and adapted that to the situation. I may have to have, I may claim intellectual property to that extent. Otherwise, the basic material is from Indian Patent Office. So we are moving on. We are trying to understand all the 10 points, 10 areas, 10 parts of the complete specification. As you can remember, the patent should have a specification, should be describing an invention, and that specification should start even if you think commonsensically. If you think commonsensically, it should start with an invention. It should have a title, right? It's common sense. And here you have a title. You have a title of a specification. It's comparatively simple one. Don't be under the impression that the patent specifications are this simple. But it would definitely depend on the nature of your invention. It could be regarding a physical, mechanical invention, like a device or something like that. So it could be a chemical thing also. It would depend. It could be from the any area of science. It could be from any area of technology. So it is a very vast area to be from. It could be. So here what we have is something which I understood, and I thought I can explain that to my esteemed audience here. So the title of the invention here is title. The specification is bedsheet tension. It is the device of which we are trying to understand the specification. It is the title of this specific title of the invention, which is described in the specification we are going to understand. So moving on with the second part of the specification, as we listed out, it is to mention the field of invention. The field of invention is the technical area, the scientific area to which this particular invention should belong. The invention belongs. This invention relates, it says so. This invention relates to improvement in device for tension of bed sheets. And then we have the third part, that is background of the invention. So please look at the title of the slide itself with regard to the drawback associated with the new art. It means that as of now, what we where we stand, where the society stands, what's the present status? What's the present state of art? Art here would mean what is the present knowledge of what do you call the present technical know-how. So, with regard to the drawback associated with the known art, or rather, here in the technical sense, in the patent sense, we can understand it. Here, there is a description of prior art. What's the present status? So, only with regard to the present status, the prior art, you can describe an invention. You have to say that the present invention is this, and this has got this such and such problems. Okay, does that make sense to you, Miss Shoniba Babu? Does that make sense to you? You're there?
Yes,
Yes,
I'm
sir.
there.
Yeah. Um, yeah, she's there. Okay, so background of the invention with regard to the drawback associated with the known art. For many people, the lack of smoothness in the lower sheet. I would request all of you to read this kindly. I will read through. We'll read together. Smoothness in the lower sheet on a bed causes discomfort, which can result in any problem of lack of sleep. There has been many proposals to tensioning a bed sheet, but these proposals have the disadvantage that a standard bed sheet bought from a shop cannot be used until it has been modified by including buttonholes or other fastening arrangements on the sheet. Does that make any sense to you, Ms. Shonima? How does that sound? How does that sound to you? Could you just tell us that in a few couple of sentences?
Actually, I'm not clear with that. Uh,
Okay, doesn't matter. Doesn't matter. So I'll just explain this. This is one of some of the simplest of the specification that we can know, read, and even this we find it difficult to understand. This is with regard to a device called one second. I'm sorry. I'm sorry. There was a disturbance. There was some technical issue. So, what is this? This is with regard to this particular invention, the background in which this invention would become important. This is about the prior art. This says that this is a description. This is with regard to the bed sheet tensioner. That's the device we have to understand. So, bed sheet tensioner becomes important in this particular context. That is what it says. For many people like you and me, smoothness in the lower bed, the bed on which we lay to sleep, on a bed causes discomfort, which can result any problem of lack of sleep. If our bed sheet doesn't is not very smooth, if there are wrinkles and if it's not properly fitting into the four corners of the bed, it will not remain properly, and that might cause some dis- discomfort. And there have been many proposals to tension a bed sheet. So there have been very many examples to tension, to keep it proper, to place it proper till morning, so that the people can sleep without any discomfort. But presently, the proposals have the disadvantage that standard bed sheet bought from a shop. Please listen to this. Please try to understand. Unless we understand this, you may not understand the story that is to follow. Bought from a shop cannot be used. It will not remain very proper on a bed and giving us comfort until it has been modified by using buttonholes. You need to have buttonholes on the four sides, and you might have some buttons on the four corners of the bed, and you might fasten it, and or any kind of fastening arrangement should be there with regard to the bed sheet. So that again causes some kind of discomfort, and here there is a problem. Though it would appear to be a simple problem, here is a problem. And this is the present state of affairs. This is the present technical, stage in which the technology has reached in this simple area. You would understand that this is simple area. And now you have an invention. In this context, you have an invention. What's the invention? These problems are overcome by present invention. And the problems which is understood, which is associated with the prior art technology, is being solved here. And here something is being offered in the form of a new device which will solve this problem, which provides a bedsheet tensioning device. Bedsheet tensioning device comprising a resilient strap. It may not make full sense to you because I want also to understand how it is. Resilient strap with releasable fasteners. With releasable fasteners at each end thereof. Each of the releasable fasteners being adapted to fasten the strap to the cloth material of a bedsheet by gripping the cloth material without any part of the fasteners being included on the cloth material. So if you're having a button to tension it, button to keep that proper, the tensioning here would mean keeping the bedsheet proper. So you need to have something attached to the bed. You need to have something like something to grip on your bedsheet also. Here there is an arrangement wherein you need not have anything extra on the bed, anything extra on the bedsheet. So you have a very easy method to solve this problem. Okay, that's a background. I'm sure that we might not have fully understood it, and that's how it should be, because we need to understand that the pattern is describing a very technical thing. Here, this is what the easiest of the example you can ever have. Okay, going further with this, the object of invention. In one form, the invention, you get to understand that this particular specification is about a particular symbol device, and there are different forms, the different incarnations, so different forms in which this device could be made, and all those are understood by the maker himself, the so-called inventor and the would-be patentee. In one form of the invention, the releasable fasteners comprises a plate having a projection with an enlarged head and engagement clip thereon. The clip adapted to realizably encase the projection under the enlarged head with the cloth material of the bedsheet trapped there between. Okay, this is the kind of language used. I just have you. I just need to you have to have such a feel. We may not have to fully understand what this is, but you may have to have an understanding that this is a technical thing. Of course, I think I'm just giving you a simple dose of the tablet. Okay. Moving further with this, you have you have further description of the invention. In another form of the invention, the releasable fasteners may comprise a pair of jaws resilably biased towards each other, such that the jaws may grip between them, the edge of bed sheet or a portion of the material within the bed sheet to tension the bed sheet as required. Only thing I wanted to convey to you is this is how one of the easiest of specification would read. It would go further. To assist with the understanding of invention, reference will now be made to the accompanying drawings, which show one example of the invention. So let's understand what this is. They've got some very introductory description, which gave us the taste of the medicine. We have some drawings. Let's see what it is and try to understand it better. And then comes the brief description of the drawing. This is another part of the specification. If you remember the listing of different parts of the invention, this is what a summary of drawings would be. And you have a figure 1, which shows one example of the bedsheet tensioning device. According to this invention, so there is an example, there is a basic drawing of the bedsheet tensioning device, and figure number 2 is about, figure number 2 shows the application, how it is used, best method of operationalizing it, right? That's what the requirement under patent law is. So figure 2 shows the application or the use of such bedsheet tensioning device to a corner of a mattress, corner of a bed. That's what it says. So you have the great invention. This is nothing like a clip, with which you can just keep keep the bed sheet properly attached to the bed. That's all. But this is patentable. This is a point I selected this particular thing to explain the most important document with regard to patent application for 2 reasons. One, this is something which I could make sense of because I don't belong to the science discipline. My science dried up when I was in +2, some 35 years back. So this is something which I could understand. A kind of clip it is. And there is another point, that is even such a simple thing could be patentable. It may not have a patent now. The patent must have expired. This is a very old patent exam. But this is something which I could understand and I could explain to you, just to give you a sense of a patent specification. And here you have the device, as said, figure number 1, and you have figure number 2, how it is used. Please don't underestimate the technicality and the use of a patent by seeing these examples. This is just for the purpose of understanding. So you just clip the bed sheet to the bed like this, and such a thing never existed before. And keeping proper bed sheet properly gives us some ease, that's for sure. So that was the problem that was existing, and that is being solved by this particular device. And they are trying to claim a patent over that. Whether they get it or not is a different question, but this is how a specification for should look like. But we are just half the way through. We have certain other parts also to be seen and understood as part of a complete specification. Shall we move on, Abjit?
Yes, sir.
Yeah, that's all. Good. Detailed description of the preferred embodiments. There are different forms, embodiments for the embodiment for the device, and the preferred, the best method is to be mentioned, right? So some of the most which you can just say more than good, best methods are being described, and this is with regard to the drawing, as we understood in the title itself. Referring to figure 1, they're trying to explain to the patent office through this specification this particular invention, this particular so-called invention. They call this as an invention. Whether this actually is a novel invention which involve inventive step and which has got utility is to be decided by what? Is to be decided by what you call decided by the patent office. So they will have to verify for these requirements, and they get to understand the nature of invention. They will take a decision as to all the 3 questions of novelty, inventive step, and what you call utility, the fundamental questions with regard to granting of patent, based on this document. But rather, this is the communication of the invention made by the inventor to the patent office to decide. So this is something like a communication format. So that's what it is. So detailed description would go like this. They are referring to figure number 1. for the ease of description, one can be seen that the bedsheet tensioning device, according to this invention, comprises an elongate resilient strap. Again, not to be fully understood. Be sure that you don't fully understand this. Strap comprised of an elastized cloth strap having loops 2 and 3 at each end thereof. The loops 2 and 3 are formed by swing at 4 and 5 respectively. After a elongate slot 6 and 7 respectively has had the loop passed there through. Yeah, let's go back and they've got some points here and there. 1, 2, 3, 4, 5, some 14 places have been identified in the figure itself. If you're seeing this, so it is with regard to this that they're trying to describe. That's what we need to understand. That's all. We may not fully understand this. And may I request somebody, Miss Verna, could you just read this further? Can you just read this slide, the content of this slide, if you don't mind, if you're there, so that I can sip a bit of coffee. Are you there, Miss Verna?
സർ ഞാൻ വായിക്കട്ടെ.
Yeah, please go on.
The elongate slot 6 and 7 are on end fastener assemblies 8 and 9 respectively. The end fastener assembly 8 comprises essentially a planar base 10 having at one end and a slot 6 substantially transfers to the direction of elongation of the planar base 10 and at the other end a substantially mushroom shaped projection 11. The projection 11 comprises a stock portion 12
and it goes on. I just wanted you to give the better taste of a technical thing. That's all. Thank you so much, Evelyn, for reading that out. I hope all of us are traveling together, and all the people who are seen virtually are in fact they're listening to this. Please do that so that I'll be encouraged to speak better. So it goes like this, and there is a detailed description which will refer to both the figures and things like that. It is technical to understand, but if you take some effort, definitely you will get to understand this particular invention and a particular description in the specification. But usually I made attempts to read some of the other specifications which lasted for 250 pages, and I could not completely understand even the first paragraph of that. So my ignorance, my lack of understanding, and my difficulty in understanding is the best proof which I can communicate you as to the technicality and technicality of the specification and the patent. So now you come to the last but one portion, but the most important portion of the specification, that is statement of claim. You have different types of claim. You have an independent claim and you have other dependent claim. Independent claim would mean it will stand by its own. Let's understand what it is. So it says like this. It goes almost like this: I or we. If there are two, definitely two or more, you will have to have plural. Otherwise, you'll start with your your first person language. This one. So I or we claim what? One, a bedsheet tensioning device. That is your claim on, comprising a resilient strap with a releasable fasteners at each end thereof. Each of the releasable fasteners being adapted to fasten the strap to the cloth material of a bedsheet by gripping the cloth material without any part of the fasteners being included on the cloth material. So no part is attached to the cloth material. You have an independent device, a simple one. You may laugh at it, but this will make us understand. So this will stand by itself. It is not referring to any other thing. It says that this is an independent claim. It says that you are claiming an invention with regard to a particular device, and that device is not the bedsheet tensioning device, and it comprises of what? So you get to understand, and the patent of gets to understand the invention claimed from the very claim itself. Claim number one is an independent claim. You understand what's the difference between independent claim and dependent claim, and the importance of claim when you go further. Okay, so continuing with this, so next one you have claim number two, which is a dependent claim. How does it become a dependent claim? You just better read this. You get to understand this. Let us read together and let me explain this to you. The device claimed in claim one. So this is referring to claim number one, which is an independent claim. So this depends on the first claim. That's how it becomes dependent claim. So this device has claimed, the device has claimed in claim number one, wherein each of the releasable fasteners comprises a plate having a projection. So what happens here is, it is referring to the first claim, which is an independent claim, and this speaks about another incarnation, another form based on this. So basically the device is the same, but it can be made in a different form also. So it depends on the first one. So this second one, which makes a reference to the first one, depends on the first one. So this is known as dependent claim. Is that clear, Havli? You're there?
Yes, sir. Okay.
Yeah. Thank you. Thank you for the response. Then it goes on. You can have very many claims, as many claims as you can claim, but definitely it should be your claim and not somebody else's claim. The bedsheet tensioning device of claim one, again, it's a dependent claim because it refers to the independent claim of claim number one, wherein the releasable fasteners comprise a pair of jaws recilially biased towards each other. So this is a different form of the same device. So the same person has understood and has the know-how to make the device in different forms. So he himself has found this all out. So it is based on different single invention and different forms of the single invention. As he is the person who has found this out, he can claim this and claim his patent or claim his right over all these forms. So there are dependent and independent claims. So it goes on in this. Actually, there are 7 claims, which is known. This is known as omnibus claim. So something like a residuary clause. Anything related to this, or gives a kind of what you call etc. etc. That's a kind of claim this would be. A bedsheet tensioning device, substantially as described, as herein described, and illustrated in the figures of the accompanying drawings. So any what you call small arrangement and rearrangement, substantially based on the present invention, is also claimed here. This is something like etc. etc. Something like this and the like. That's how we say this. So and the like are also claimed here. This is an omnibus claim, and definitely you need to have a signature. That's commonsensical, and definitely you need to have a date. This date is also important, maybe because you write your priority with regard to the invention on the day on which this particular invention or specification is claimed. Now we are reaching the last foot of a specification, that is an abstract. The abstract of the invention. So abstract would mean abstract. It gives a very brief but a kind of exhaustive idea about the invention. Usually what is being published in a patent journal is an abstract of the invention. Then a person who is looking for any kind of proceeding with regard to that. For example, when you make a claim for a patent, you are not straight away given this. This will be examined at the patent office. Then this will be published so that others can have objection with regard to this. So when for that purpose, we should be giving, the patent office should be giving some kind of brief idea at least with regard to the claimed invention. So what patent office usually publishes is the abstract, of course. So reading the abstract, the person who might object to this, who is looking for some sort of who might have any objection with regard to this, will understand what nature of this invention and what nature is the invention, so that he can read further and understand the real nature of the invention. And based on that, if he or she has an objection, he can file that or she can file that. That's the very purpose of abstract. So this serves the purpose as I described. Okay, so this is the 10th of the last part of the specification. So I think this gives us a a feel of the invention, and this is usually usually drafted by a patent attorney who has was technical knowledge and who might have some legal knowledge also. But what is essential qualification for a patent attorney is technical knowledge. He should be a person with MSc or BTech. That's basic qualification. And law is not at all a requirement. Law is just a desirable qualification. Kindly do understand. So we need to have some more ideas about claims. I'm going to describe that. As I said, claims define the scope of protection of patent. Claims define the scope of protection of patent. Reading all the 5 or 7 or 10 or 25 claims, you get to understand the pattern of gets to understand what is the width and length of the patent is. If there is a question, if there is a case with regard to that, if I'm the patentee, if I am filing an infringement suit against Mr. Abjit here, I'm saying that Mr. Abjit has copied and making use of my patent. Then what is to be done? What court will do is they will try to understand the scope of my patent. Then they will try to understand the scope and nature of Mr. Abjit's patent. Then they will go for a comparison. That's what going to happen. That's what infringement suit is all about. So first of all, the scope of my patent is to be understood. For that purpose, court will look at the claims, and even to understand the consider the application for patent. The most important thing that is being considered by the patent office is the claims. So in every aspect, or rather, patent would mean the scope of claims and the interpretation of that. Interpretation of claims would become an important part, because the nature of patent and the extent of patent is determined by looking at the claims. Claim is a statement of technical facts expressed in legal terms, defining the scope of the invention. Claims is a statement of technical facts expressing in legal terms. As I said, it's a techno-legal document defining the scope of the invention, and it defines what will infringe the patent. That's why I was bringing in Abjit here. So if Abjit is a person who is working in the same area, you should be careful. It's a notice to him saying that if you enter into my territory, which you can understand through the claims, you should not enter into this. This is a kind of trespass in a way. So it defines what will infringe the patent, telling you all it's a right and rem. Going to the basics of jurisprudence, right and rem. So I'm telling the entire world, if I'm the patentee, that this is my area of right, and these interests of mine. Right is nothing but an interest which is recognized and protected by law. Going back to the basics of jurisprudence. So I'm telling the whole world in the right and rem form that I've got these rights in the form of claims, which is the extent of patent, and don't enter into this. You don't have a right. If you go to the Hoffelt, the second sense, you have the liberty to do this. I have the liberty to do this, and you have no right to enter into my territory. Does that sound enough legal? I hope it is. And going further, the first claim is the main claim. Here, the main claim, and it is the independent claim. The subsidiary claims or the dependent claim refer to the main claim and include qualifying or explanatory clauses or optional features. Optional features. I stand corrected. And totality of the claims must relate to one invention only. Though there are different claims, one main claim and there are subsidiary claims or dependent claim, all these are with regard to one invention. If it is with regard to two devices, it is with regard to two inventions, which cannot be claimed in one patent application, one specification. One specification and one application can be with regard to one invention only. That is a basic requirement of a patent application under patent law. One invention only. I emphasize that. So that's all about specification. So we have a specification, and this is what we need to file for the purpose of registration. Now, what we are going to discuss, or we are trying to understand, in brief at least, this can be understood in 2 hours or 3 hours or 4 hours, 5 hours. It can take as much hours as possible, but we may be spending just 10 minutes on this. This is a procedure. This is the graphical representation of the patent registration procedure. I hope the graphical representation is visible to all of us, because it is printed in small form, because I wanted everything in one slide so that I can explain and you can understand. So Abhijit, is that visible?
Yes, sir.
Yes, sir. Visible.
Thank you. Thank you for the response. And so you make a patent application. Yeah. Advocate Shonima Babu Law. Great. Thank you. Patent application. You make a patent application, and it is kept idle, at least as far as you are concerned. Nothing is being done with regard to that for 18 months. There are certain reasons for that, which we may not go into. But for the first 18 months, nothing is done, because usually you have some period for what do you call what do you call provision specification. Then you have a complete specification. Then you may have to give the people from other countries some time to file after making application in their country. All these requirements are there, which we may not go into, but please do understand that there is a justification for this 18 months. So for 18 months, it remains idle. But if you want a patent application to be published earlier, you may have to make a special application. You might pay a fee also. Then there is a application format and the first schedule, and then fees also mentioned there. Then you'll have to make all those. So then you can go for expedite your patent registration procedure. But usually, no, it remains idle for 18 months. Once you complete the period, once the patent office completes a period of 18 months from the date on which your priority date starts to run, then you have a publication. Patent specification, patent application along with patent specification. Patent specification is the document, is the most important document, is being published in something known as patent journal. It is as good as the publication of the official gazette, and which has got online. So these days you also have soft copies. There is a patent journal available. The person interested me look into that. The people who are working in the same area, the the companies in competition would look at this. So the people interested, which can include you and me, can look at this. Now look at the word publication there in the picture. From there are two there are two sites happening. You have an examination from the patent office on the one side. So patent office makes an examination. So this is done by the concerned section or concerned department, because this would mean this is something like a mechanical device. So it may not go to a chemical section. It may not go to a biological section. It will go to that particular mechanical section. And people there, examiners, we would call them as the patent examiners in the patent office. Patent examiners would look into this. And based on what are they evaluate this? They're going to evaluate 4 questions. They're going to evaluate this particular application and specification. They're going to read and understand and try to evaluate based on 4 criteria. What are the 4 criteria? First one, whether this has got novelty, which we have already understood. Whether it involves inventive step, the second requirement, if you can remember. And the third one also is also important. Is it having positive utility? And does that make a best and particular description? Is the description clear enough? These are the 4 considerations based on which they are good examiners. We may not go further details into this. This is very technical, which we may not understand, but please do understand that one of the ways in which there are twin method, which we can call as twin method, to ensure the thing that is claimed is in fact novelty, is having novelty, and it complies with other requirements. So one aspect, one way of looking at it is or ensuring that is examination in the patent office. So examiners, examiners of the concerned department, concerned section, will look for all the 4 requirements: novelty, inventive step, and utility, and best method of performing this full and particular description of that. So disclosure, proper disclosure, best method, the best way. That's also an important factor. So if patent examiners find that this is not new, it's not complying with all the requirements, then what happens? Commonsensically, it should be rejected. It is not complying with the requirement of patent law, so it is rejected. But things need not be pessimistic always. It could be now positive also. There could be situations where you pass the examination. Usually what happens is you'll have some objections here and there. Then you may have to have you may have to have some clarification made to the patent office. You may have to go for a hearing on the objection made by the patent examiners. That you may have to clarify it. Ultimately, if you can properly clarify and convince them, you get pass. You get pass mark the examination. So if you get pass mark in the examination, if you pass this test of patent examiners, you go for the second. Once it is ensured by the patent examiners that this is, at least for them, they've got their own arrangements. They've got all the materials relating to patent filed in the Indian Patent Office since 1st April 1912, because that's the date on which Indian Patent Office is Patent Office started functioning. They've got all the materials now digitized in the digitized form available with them. And apart from that, they've got arrangements with very many main patent office like EPO, European Patent Office, Japanese Patent Office, Chinese Patent Office, UK Patent Office, US Patent Office, and very many main patent offices they've got arrangement with. They also all have their materials available with them, with them, and that is being shared with us. And in this digital era, it can be done easily. And we do the same. This is a mutual arrangement. We share our ideas and our materials with them as well. And when they go for a search in-house in their patent office, they search even in our document, because the requirement for every country, as per the TRIPS agreement, the WTO TRIPS agreement, which is the international agreement with regard to intellectual property, the requirement is this: it should comply with the requirement of patent everywhere in the world. If it is prior used, if it is prior known, or if it is prior published, anywhere in the world, that's a requirement. Anywhere in the world, then there is no patent. So we need to have examination, patent examination, patent examiners examining this document with regard to documents anywhere in the world. That's the reason why we have got arrangements with all these countries. So this is practical, pragmatic, common sense, right? So you are going through all this. We'll speak more about patent examination and patent examiner's report later on, maybe after a couple of minutes. And then you go for once you pass the examination there, once you get a green signal, you go for the second one. What happens is this is given to the public, because it's sure that it's 101% sure that patent offices, if you consider all the 193 patent offices in all the countries, you will not have all the information with regard to mankind with them, because all the information are not patented for the obvious reasons. Many things are evolving. Many people may not go for invention. So if you think about masala dosa, to give a jovial example, if you think about masala dosa, it's not a technical thing to be patented, but if you think of masala dosa, you will not find the the technical know-how with regard to masala dosa in the patent office. To put it in simple words, in a jovial way. It's only a lighter example. Don't take it very seriously, but I think it conveys the idea I wanted to convey. So what happens is, whatever be the kind of search you make, whatever be the kind of search you make, whatever the kind of patent examination you make, it cannot give a foolproof idea. That examination cannot be foolproof. There could be any person that's somewhere in the some corner of the world who might say that I did not have a patent over this, but I have seen this, or I've made this, or I've seen somebody using this. That possibility cannot be ruled out. And that's the reason why, acknowledging that fact, patent law says patent examination and patent search in the patent office is not exhaustive. You need to have opinion from the public also. So you give this after examination on all the procedure that might happen there, some kind of objection. If it is there, you go for opposition from public. There is a stipulated period for people to oppose, and there is a specific period. So you might have heard about Texmadi patents that was granted in America. So what they did is they've got some we have a basmati. They just took it and they made some changes. Some changes to its texture or some other matter, and that was given as a specification. They made an application, and at that point we did not know much. India did not know much, and or even our institutions did not know much about this patent. And although we had a patent law for quite a long time, we were not at all concerned about unless we joined WTO. So patent was granted to Texmadi, which is just a variation of basmati there. But later on we found and we got it cancelled. Anyway, that's how it goes. So there is a time for patent opposition by public. So anybody, people like including you and me, usually it is the people who work in the same area who make objection if at all there. But any person, any Tom, Dick, and Harry, to put it in that way, any person can make an application opposing this, saying that I've got an objection, I've got something which is similar to that of this. So you should not be granted a patent of that. That will be the tone and tenor of an opposition. Then definitely there is going to be hearing, and if you come out colorfully, you pass both the test. So you pass the formal test, you pass the informal test also from the public. Okay, so once you pass a twin procedure here, the patent search in the patent office and also opposition from the public, and then definitely it will be granted. And goes without saying, if the person who is opposing it becomes successful, then definitely he's saying that he convinced the patent office that I've got something which is similar to that of this, and your supposed patent, supposed claim is not at all a claim. It's already existing. It's not complying with the requirements of patent under patent law. So then there is a rejection. I think the diagram is making sense. Does that? Let me ask someone, Heavily. Does that?
Yes, sir.
Yeah. Then, after complying with both the requirements, it is presumed by patent law. I again use the word presume. Here, it need not be foolproof again. It will be presumed that nobody in the world has got this particular invention. This is in fact new, involves inventive step, and it has got utility, and other requirements can be checked at the patent office in itself. And the most important thing is the possibility of another invention, another inventor, not or another person who has got some know-how with regard to this, who has not seen this. So usually, if there is no objection, it will be considered that it will be presumed that there is nobody who is having a similar thing in the world. So this is in fact novel, and so there is a possibility of giving a patent. So you come to the at the central point in the diagram. There is a grant with regard to that. There is a grant. So you are being granted a patent From that way onwards, you are not just an applicant, you are a patentee. Once you are granted a patent, you are a patentee. So I'll take a few minutes more. Of course, I suppose I have got some time more to speak. Maybe if I'll take another 5 minutes. Do I have the permission for that, Miss Evelyn?
Sure, sir. Sure.
Yeah. Thank you. Thank you for the thank you for the gesture. So moving on with this, after grant, again there is a publication of grant. Definitely, that is being published in the patent journal. So once it is granted patent, then this grant is being known to the being made known to the world. And again, within 12 months, anybody can object to that. There could be a notice of objection. I think we are just going down. Please pay your attention to the down part of the diagram. So within 12 months, you can give you have a possibility of giving a notice of opposition again. And if there is a opposition with substance, then definitely that there is a procedure going on there. There is something like a court proceeding. It would be something like a quasi-judicial proceeding. It will be something like a quasi-judicial proceeding. Sometimes you will have a patent attorney appearing for you, or you can appear yourself, and there will be an opposer on the side, he himself or through patent attorney. He may be appearing. Again, you have a proceeding, and if you come successfully, you have a better patent. But if you fail, and if the person opposing succeeds, then your patent is invalidated. Your patent is invalidated, and your patent is revoked. And please to understand, even after this, even after this, there is a possibility. Even after this period of 12 months after the grant, also there is a possibility of somebody coming forward and saying that your patent granted in 2022 was in fact not a patent, because I had a patent. I had something like this one, which was found by me or found by somebody in some corner of the world, and in view of that, you were not entitled for a patent. Then even after this period of 12 months, there is a possibility of patent being rejected, patent being cancelled. So patent is always, it's not a complete document. Even a patent registration certificate is just a presumption certificate, I would say. It's not it cannot be equated with a title deed. It's not as good as a title deed. It is just a registration certificate, which can be in trouble, which can be in troubled waters, and it could be in suit even after this 12 months period of post-grant opposition period, right? So, and please do understand, the patent period is for 20 years, and this period of 20 years is not, kindly note, this is not calculated from the date of grant. This is calculated from the date of application. Go to the first column, first box in the diagram. Once granted, maybe this is granted after 4 years or 5 years of the application. It is granted after 3 or 4 or 5 years after the application. So if you make an application in 2022, you may be granted a patent in 2027. Even though it is granted in 27, if it is granted in 27, this will date back to 2022. So 20 years will be calculated from 2022, not from 2027. Kindly note. That makes a lot of difference. So if it is calculated from 2027, you get 5 years 5 years on that side. You get extended 5 years. For 5 years, you have got exclusive right in the entire world, at least in India. That makes a lot of difference. But please do understand, it is considered, it is calculated from the date of application. So when it is considered like this, you have got certain advantages there as well. So I think that this is good enough for the day, and we have reached a particular stage where you can stop. Now we will have to move to other aspects relating to patent application, examination of patent application and related matters, which I think we can do in the next class, possible class. If you have any clarification to make with regard to the matters we discussed today, kindly do that. I'll try to live up to your expectation. Otherwise, we will call this a day.
Thank you so
Thank
much,
you, sir.
for the
Thank you for your presence, officer. Your presence is underlined. Thank you.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the Council of Composition of the Council?